Hello, my name is Chris Johnson, and I am a business lawyer and business person. My first business I started in college. It was reasonably successful, and I decided to go to law school, and there was an opportunity to sell it. And so I did, and I had absolutely no idea what I was doing, but I went ahead and did it anyway. I learned a lot from that situation. Then I learned a whole lot being a lawyer later on and actually doing mergers and acquisitions. While mergers and acquisitions are actually quite complex, I want to demystify the corporate transaction for you. I want to put it in simpler terms and really just break up the key parts that you, as a non-attorney, should understand while you're dealing with your attorney who's going to work on the complex issues. But it's important for you to understand just the key framework. So I like to think about this as the anatomy of a body, the anatomy of a corporate transaction, and I've broken it up into five key parts of this body. One, what is being purchased? Two, how is it being paid for? Three, the reps and warranties. Four, indemnification. Five, closing deliverables. And I'm going to break each of these up for you. So what is being purchased? There's really two main types of a sale, and that's an asset sale and a stock sale. An asset sale, you're only selling the assets of the company, and the liabilities are typically being retained by the seller unless certain liabilities are being assumed by the buyer. The asset sale, think about it like a clean start. And that's why the buyer likes an asset sale, is because they're just getting that asset. They're not getting any of the liabilities. They're not getting any of the baggage. The assets are going to go into a new entity, and it's a fresh start. And then you have a stock sale. That's not a fresh start. And that one, the buyer is going to step into the ownership of the company. They're going to receive the ownership interest of the company, and they're going to step into the company. If there's any liabilities in the company, if there's any baggage in the company, then that buyer is going to have to deal with it. And that's why oftentimes buyers don't want to deal with these things. Fun fact, a lot of brokers and other people like to structure asset sales as asset sales rather than stock sales, because stock sales might implicate the securities laws, which an attorney should look at if you're going to structure it in that way. And there are tax benefits either way you structure this, a little bit on either side. That's something to consider too. And you should talk to your accountant about that. That's outside the scope of this presentation. So what kind of assets are there? Well, there's hard assets of the company like machinery, equipment, things like that. There's also goodwill of the company, just the name of the company, a going concern. And with a lot of service businesses, things like that, there aren't going to be hard assets. It's not like it's a manufacturing plant. Most of their asset really is in the form of goodwill that you're buying. Contracts are part of the assets. They're going to have to be assigned over. And then you have the customers. And you can't buy people, so you really can't buy the customers. But what you're buying is essentially the customer list. And the way to tie up those customers is by making sure that you have a non-compete in place. And that non-compete is really narrowly drafted to protect you, because you're going to pay, you being the buyer, is going to pay money to purchase essentially these customers, this business. And you want to make sure that the seller doesn't just take that money and then go open up shop across the street and start poaching those customers and doing the same thing and take them away. It could be catastrophic. And I've actually seen it done several times. We've had several cases where we've seen this type of behavior done by a seller where they feel entitled, like they can just go ahead and sell their business, pocket a couple $1 million, open up shop right down the street, and then compete against the buyer. Very frustrating for a buyer, and you want to make sure that you lock that part of the transaction up. Second part is, how is it being paid? So there's cash, there's stock, there's seller note, and there's an earnout. And let me just tell you the most important thing that I think you should understand is that, as a general rule of thumb, The buyer wants to hold back as much of the purchase price as possible and come out of pocket the least amount. The seller, on the other hand, wants as much cash in their pocket right at closing. So that's a general rule of thumb. So what are some of the things that a buyer might do? So a buyer might come in and say, I'm going to pay you a little bit down and I want a lot of the rest on a seller's note. Okay. Seller's note has its own issues for the seller, because you want to make sure that there's a personal guarantee tied to that seller's note. You want to make sure that there's a security agreement tied to that seller's note. You want to make sure that you can even if there's a personal guarantee and there's a security agreement, that it's going to mean something in the event there's a default. Taking a seller's note as a seller shifts the risk over to the seller in the event that the business actually fails, that the seller sells the business and 6 months later, the buyer runs it into the ground and the seller is owed a couple $1 million and the buyer says, sorry, won't pay you. I can't tell you how many times I've seen draft documents come to me, especially when there's just a broker involved and there's no personal guarantee. I even was on a call with the broker who was supposed to be representing my seller, and my client was like, why is there no personal guarantee in here? And the broker's like, I don't know. Like, he acted puzzled. And I'm like, guy, you've been doing transactions like this for 20 years. You know damn well it's because the buyer wants the option of throwing that company into bankruptcy and not paying that note and screwing my client. And we're absolutely going to have a personal guarantee here. That's a non-starter if we're going to have any kind of seller's note. Now, like I said, having all the cash up front is still the best for the seller. I'm going to touch the last piece, which is an earnout. So what is an earnout? Earnout is an amount that's paid based on a performance metric. So buyers oftentimes want the seller principal, like the main owner and operator of the business, to stay on the business for a couple years to help transition customers and to help just transition the business. And the buyer will give an incentive to the seller to do a good job, to maybe take the company from 1 million a year to 1.5 million a year, 1.5 million a year to 2 million a year. And if that's done, then certain bonuses are given. That's fine if it's a pure bonus. Here's what to look at for the seller. If you are the seller, make sure you get what you want out of the transaction. So if you wanted 2 million for your business, make sure you get 2 million, and then the earnout is a bonus. Don't take half of the purchase price in an earnout. I wouldn't advise that. So that would be taking 1 million in cash, or even worse, in a seller's note, then the other $1 million based on performance bonuses. Determining whether those should get paid can be questionable sometimes. It involves numbers that the buyer is privy to, and then the seller has audit rights, and it gets complicated. But it's best to keep things simple. It's best to try to avoid any disputes in the future. If you're the seller, the easiest way, absolute easiest way to do it is get your cash, and that's it. Now, if you're the buyer, you want to hedge your risks. So the best way to do it there is to come out of pocket on your cash the least amount possible. The next part of a corporate transaction that I want to discuss are your reps and warranties, your representations and your warranties. And both the seller and the buyer are going to make reps and warranties. It's part of the due diligence process with the buyer. The buyer is going to have the seller make a bunch of promises. And sometimes the seller has knowledge, sometimes the seller may not. For instance, it could be an environmental, just a straight up promise, there's no environmental problems with this property. And the seller might say, well, I don't know if there's any environmental problems. There could have been something that happened 100 years ago. The buyer's response, which I think is pretty reasonable with some reps and warranties, is, I don't care. That representation is my insurance policy. You're going to take the risk. So reps and warranties are essentially an insurance policy. They're a shifting of the risk, and they help define what is being sold as well. Can't tell you how many times I've seen where the parties think they have a meeting of the minds as to what they're buying, and then you go through the reps and warranties and you're listing out contracts and you're identifying other assets, and then the seller maybe gets concerned about identifying some things and issues come up and you're negotiating it, and the buyer realizes, wow, this transaction doesn't look 100% what I thought it was. It looks kind of 90% of what I thought it was. So the reps and warranties might be obnoxious to you as the non-attorney because I know they're really confusing. They're one of the most confusing things in the transaction. The lawyer should be heavily involved in the reps and warranties, but there's a reason that your lawyer is negotiating these heavily, and these are some of the reasons, and they're there to protect you, buyer and seller. There's some reps and warranties that the buyer should be making that are going to protect you as well as the seller of the company. Indemnification kind of acts like the reps and warranties. Again, it's kind of like an insurance policy, but it protects against third-party claims. And oftentimes these indemnifications will be tied back to the reps and warranties as a very important part of the contract. If there's any breach of those, it'll also trigger the indemnification as another way to enforce the reps and warranties. Again, this language is very confusing too. I notice clients' eyes gloss over when they're going through this, but just know it protects against third-party claims, and it's just another form of like a private insurance policy between the parties, and it is an important part of the contract, and it's not something to gloss over. A lot of mistakes can be made. The language is very important in indemnification agreements. The final part of a corporate transaction is the closing deliverables. That is the transfer of those things that are actually being purchased. There's no point in purchasing something if you don't effectively, through a legal instrument, transfer those things over. So now you have an ownership as the buyer, you have an ownership interest in those assets being purchased, also in the contracts, everything like that. You want to make sure ownership's transferred over. And you also want to make sure that all the appropriate authorizations are there, that the seller is authorized to conduct the transaction, transfer the assets, and likewise, similarly, for the buyer, that those authorizations are there. It may seem like a bunch of legal unnecessary stuff, but trust me, it's very necessary to make sure that this transaction is done properly, and it can't be fought over and challenged later by someone when there's a dispute. And disputes do come up. That's why you want to make sure the transaction itself is as airtight as possible. If anyone wants to talk to me about the anatomy of a corporate transaction, you can schedule an appointment at calendly.com/Chris Johnson. And Johnson is spelled Johnsen. I hope that you thought this was helpful. I really tried to distill a very complicated transaction into 5 key parts. So the key parts that I feel are the most necessary for you just to have a basic background on, so you can understand what's going on and what your attorneys are doing in this transaction. Thanks.